Thanks, Penny. So, Mr. Chairman, we'd be happy to answer any questions if you'd like.
If I just ask one question on co-governance, co-management, I didn't see any restriction in the plan to Maori land. Is that, have I missed something, or is that you intend to put a restriction in?
So in the conversations that we've had with iwi who are interested in that co-governance, there is co-governance, so we've got co-governance under the Reserve Management Act, which is a separate thing where there already are co-governance arrangements in Auckland. Example of that is Bastion Point, which for many years has been co-governed by the former Auckland City and Ngāti Whātua, and that's as the management of the reserve, as a reserve. And so that co-governance has been around for a while. We also have co-governance arrangements on reserves in terms of places up on the Kaipara. Once again, they're reserves, and it's a co-governance arrangement between the local iwi about the management of that land as a reserve. In terms of co-governance of the iwi land, etc., the only conversations we've had with iwi are about their own land, not about any other land across Auckland.
But still haven't answered the question.
It doesn't say anything about their own land in the relevant passages that I read. Am I taking it that you will be applying to restrict that to either the reserves or to Maori-owned land?
What the Unitary Plan indicates is that is an opportunity for iwi to ask the question of Council. How the governing body chooses to apply that is really a choice for the governing body of that time.
It doesn't say anything about opportunities to ask questions.
It's not about asking questions. It's if an iwi group wishes to enter into a transfer of power arrangement, that has to be signed off by the governing body. At that time, it will be the governing body who indicates what level of transfer of powers it's prepared to agree to. All the Unitary Plan does is set in place that opportunity for that discussion to happen between iwi and the governing body.
Okay, down here.
Ancestral lands, does that effectively mean all of Auckland, where what defines ancestral land? Can you repeat the question?
So the question was, does ancestral lands apply to the whole of Auckland?
Well, we're taking a form I have occupied previously.
So I haven't got in front of me the legal, so there will be a legal interpretation of ancestral lands, but those are lands that they have now, for example, Ngāti Whātua at Ōrākei, that's their ancestral lands that they have received as given back to them through the treaty settlement process.
So it doesn't include private land, there's no private land where they may occupy?
Yes, it does. There's no definition of ancestral land that it appears to be intended in the plan to cover any land that they once had a connection with.
Mr. Chairman, that's not the intention of the Unitary Plan.
Yeah, but
Well, that's what it says.
Well, no. Take our advice that that's not the intention, that it covers any land that they once had an interest in. That's what I think they're saying.
Well, there are a lot of intentions that are not covered and do come through at a later date because it is not written properly in the unit. Can I just ask?
Sorry, there are other people who've got their hand up first. Can we go? I think you say yes.
Yes, I'd like to know one thing about this matter of national importance. If I find a handful of old pipi shells on my land where a few Maoris had a feed a few hundred years ago, is that a matter of national importance? Yes or no?
So just so that everyone can hear the question. So the question was, if I find on my land some indication of a Maori having had a meal in that site hundreds of years ago, is that a matter of national importance? Okay, so just to re-quote what Penny quoted, the Section 6, Part 2 of the Resource Management Act says that that any organisation administering the Act, which in this case is Council, must recognise and provide for the following matters of national importance. And under subsection E it says the relationship of Maori and their culture and traditions with their ancestral lands, water, sites, wahi tapu and other taonga. So what the Council has done is put in place a rule in the Proposed Auckland Unitary Plan to address that provision of the Resource Management Act. But in order to be able to answer the sort of question you're asking, the people who really know the cultural heritage about any particular site are the local iwi. So that's why the provisions allow us to consult the local iwi, or the applicant to consult the local iwi as to what is the cultural heritage associated with that particular site. I think just in the middle there.
Well, I wasn't being frivolous asking that question by any means. I've had that experience on a subdivision which I was managing, actually in Tauranga. And we stripped the topsoil and Maoris came from all over the place looking for pipi shells. And they found a few pipi shells and they suddenly became sacred pipi shells. We had to get consent of the local iwi before the earthworks could continue. To cut a long story short, we had to pay about $20,000 in cold cash to the iwi to make those sacred pipi shells unsacred. That was the price
We hear your concern, but just to put it in context, what Penny Parrott explained to you the numbers, that we've had 6,000 resource consent applications to our resource consents group in the last 6 months. Of those, 187 triggered the CIA provisions, the possibility of requiring a CIA. Of those, only 12 consents in total required a cultural impact assessment. So that's 12 out of 6,000. So yes, Sue in the middle.
Yes. That's only 6 months.
6 months.
I asked the question earlier about the 3,600 sites, and there was a screen put up indicating that a number of them had been already investigated by the Archaeological Society and found not to be of any value. Are you saying that although they have been investigated, if the iwi decide that they are of value, all of a sudden the previous investigation is overridden?
Yep.
So the work that was done by the Archaeological Association was very much based on archaeology, and they identified sites of Maori origin, and they've obviously identified sites of European origin in their archaeological work. And in terms of making a final decision about whether or not those sites remain or are of value, that has to lie with mana whenua, because it's sites of value to mana whenua, not sites of value to archaeologists.
So what you're saying is a group of professionals investigating the matter and finding nothing of value are overruled by the recollections of a group of people that they believe it may have some sort of value.
So in terms of...
There is one group of people that have the opportunity to say, oh shit, I remember that I was told by someone some time ago that this was of value to us.
So we, as I've said, are using the experience of advice related to the issue. So if we have a transport issue, we rely on traffic engineers. If we are asking a question about is this of value to mana whenua, then we have to rely on the expertise of mana whenua. Now, they, as you've seen by these figures, are being quite responsible in their responses back about whether or not they believe it has value, because only 12 CIAs were required out of the total number of resource consents that could have triggered a CIA.
I'm talking about the 3,600 that has been investigated, but now you're saying that investigation, by professionals presumably, has been overridden by oral history.
So the investigations were by archaeological people who were focused on archaeological issues, on remains. What they've identified are sites which have value, could potentially have value to mana whenua. and that is what we are working through at the moment. And they're quite different expertise that we're talking about.
Your question. Have you a question?
Yes. How does the council define the iwi that you're going to take part in speaking?
So just for everyone who may not have heard that, so the question is, how does council define iwi? So council relies on the iwi authorities determining which are the relevant authorities. There are 19 iwi authorities in Auckland. We rely on them to identify that, but there is legislative provision under the iwi authorities legislation for them to make that determination.
Just taking your example of traffic engineering back. A traffic engineer does tertiary education. He does many, many years of university and everything else. What qualifications do you have for a mana whenua representative to go out and do a CIA, and who critiques his qualifications? As we all know that Maori never had a written language, and there isn't a purebred Maori left. So who critiques his qualifications, and what gives him the qualifications to go out and do a cultural assessment, or say that there is something of significance that he can remember, or who can remember? Yeah. I mean, it's only
Can I make one thing clear? It's the question to mana whenua is there a cultural impact assessment needed on this site? That is, are the cultural heritage values associated with this site such that it requires a cultural impact assessment? Now, the people who have the knowledge to answer that question are mana whenua. They are the ones who understand and have the knowledge of the cultural history and heritage of particular sites, so they are the only people, in fact, who can answer that question.
How do you know?
Because it is their cultural history and their cultural heritage.
There is nothing in writing to show that at all.
The question that is being asked of us through the Resource Management Act is identifying and respecting the cultural history and heritage of mana whenua. And the only people who can answer that question are mana whenua.
Well, Mr. Blakely, that's an interesting point. I've got, I'm on either side of me, I've got two ladies who are Kaitiaki. They come from South Kaipara. I don't think either of them would claim to have knowledge of all the mana whenua sites that you've identified on the South Kaipara Head Peninsula. So I think it's interesting that you're making an assumption, the council's making an assumption that just because somebody is born somewhere, come from somewhere, it makes them an immediate expert or authority on mana whenua sites. I think that is a flawed thought, really. I think that's flawed, that thinking.
In case everyone didn't hear that, the question was really the council should not assume that mana whenua have knowledge of the cultural heritage associated with particular sites. Exactly. So the answer to that is that it's the mana whenua themselves who are saying to us that they want to take responsibility for advising on the cultural heritage associated with the site. They will appoint a person who has the requisite knowledge to investigate that particular issue. And so the iwi that we have talked to have made it very clear that they will take responsibility to make sure someone who does have that knowledge is advised.
Excuse me, Dr. Blakely, but I think you've got 3,600 sites. At Southhead, on my own property, I've got 9 sites. I don't know of anybody in the local Māori. Unfortunately, the elders have passed away. The young people have never worked on the land out where we are. And I doubt very much that there'd be anybody locally that would know much about the mana whenua sites in our South Kaipara area. I really think it's a flawed thinking, and it's wrong to make an assumption that local iwi are experts on these sites, and just because they live locally today. Unfortunately, I think that's...
So we're not making an assumption.
You are.
The the 19 mana whenua, the iwi who have been working with us on the unitary plan process, have all identified contacts who, if a CIA is required, that contact is the person that, and they themselves have indicated, will be able to make a decision of whether a CIA is required or not. It is not our role to question whether or not the people they have put up to represent them are equally, it's not our role to question when other people put technical experts in.
It is your responsibility on our behalf to check people are qualified.
You can see where this legislation is shoddy. You can see where this issue is not distinct in law, and you can see how it cannot be applied fairly in Auckland. And there's only one solution to this. It's for John Key and his government to step up and sort this out. And he's got to do it. He's got to do it fairly quickly as well, because this sort of legislation will be happening throughout councils in New Zealand, and it just cannot be put this way to the citizens. We're powerless in this. We cannot get effective change, and I call upon the government, who is sovereign, to sort it out. Because I mean,
Lee,
Graham.
Can I just come back to where this whole thing started? Penny, you refer to justification for this whole being sites of national importance. Yes, Graham Painter, I represent the Omaha Beach community. Our understanding is that you should have been relying on Rule 86 or Section 86B of the Resource Management Act in order to give legal effect. And we did have this discussion some many months ago in your office. 86B says you may give legal effect to protect sites of historic heritage. Now what we have here is, out of the 3,600 sites, and I use Omaha as an example, we have 4 sites of genuine significance that have been protected, and another 10 sites that have been determined by the iwi and the archaeologists as being of no significance. And also, of course, we have another dozen or so sites which were determined to be of significance, which you haven't protected in the unitary plan. My last point indicates that the homework hasn't been done properly, but my first point is, how can you protect 3,600 sites when the law says to protect historic heritage? Now, your justification is that you are precautionary, but I don't believe that the words protect historic heritage, these are positive words in a legal sense, but your justification is that you are taking a precautionary approach, which means just in case something may be of significance. Can you answer that?
So in terms of that, I think your point, Graham, is you're questioning why the sites of value to mana whenua have legal effect at the moment. Is that your point?
Correct.
So I'm not an RMA lawyer, and the legal advice from our RMA lawyers is that those do fit under the historic heritage in the part of the Act that you quoted. I don't think there's much point in having a discussion about whether that's right or wrong at the moment, because it's clear there are no RMA lawyers in here, and but that is the advice that we have been given by the Council's RMA lawyers, which is why they have effect at the moment.
Sorry, Graham, I'll just pick up your question also around the precautionary principle. You see, there's an exact analogy between the precautionary principle being applied to this mana whenua cultural heritage and the precautionary principle being applied to historic heritage in the rest of Auckland. So the issue there is that any building that was built before pre-1944 there's a demolition control. We don't know exactly what the heritage value of that may be. So there's a requirement to assess the historic value before a decision is made which would allow demolition. Now, it's exactly the same principle for the mana whenua historic heritage. In some of these sites we don't know exactly what the cultural heritage value. We're saying a precautionary approach is warranted, therefore we'll test out whether a cultural impact assessment is needed or not. If it's not needed, then the resource consent would go ahead. It's exactly the same principle. So why is everyone up in arms about a mana whenua provision but not about the other historic heritage provisions?
Hang on, I think, if I could just help out a wee bit here, I don't think we've gone into a legal argument about this, but I'd be happy to argue that in a court of law. But anyway, there are distinctions between the two. Can I just come back to another point? Penny, you said that council is now taking responsibility on any sites which impact on a development proposal. Now, we have raised this with you since early in the year. Why has this is the first public utterance I've heard that you are taking responsibility. Why has not this been publicly notified?
So I'm sorry to contradict you, Graham, but when the resource consenting team first put in place this process, there was a media release on it, and also it went up onto our website indicating that. So you might have missed that. It was over 6 months ago, but certainly as soon as it was raised by a number of people of the concerns of having to individually go out and contact mana whenua, the resource consent team got the funding from the governing body to set up a team of people who have now taken that role on. So it is available on the website. There was a media release on it back around 6 or 7 months ago.
Well, I can assure
and I think it also was in our Auckland, but I can't check on
I can assure you that there are still certain council officers that don't know anything about your media release or your website. I myself was required to lodge a resource consent because we were within the buffer zone of a so-called site of cultural significance, which of course is not a site of cultural significance. However, moving right on from that, so I would ask that you make this a little better known to the public at large and to your officers. But you also made the comment that through your own investigative process, you're in the process of withdrawing certain sites from your overlay. Now, how long is this going to take? Will it take the whole 2 years of the unitary plan process, or are you going to remove sites as you determine they are no longer of significance? Because as you know, there are sites sitting at Omaha Beach right now that are of no cultural significance, as recognised by the iwi and by the archaeologists. So if you've initiated this process, when is it going to have effect?
So in terms of being able to change the unitary plan, that's not currently within the power of the Auckland Council. Once it was notified and the submissions handed over to the Independent Hearings Panel, the legislation that applies to us precludes us from doing what we would normally be able to do under the normal statute. So what we're doing is, as I've said, we're working through those 3,600 sites. I think we said we've gone through around 2,000 of them. We will be in a position when this issue comes before the Independent Hearings Panel to indicate to them those which we believe we have identified that there is no need for them to be subject to that layer. What the Independent Hearings Panel chooses to do with that information at that time, we will have to wait and see. They do have the ability to make recommendations before July 2016. If they do make a recommendation, then the Council has to respond to that within 20 working days. At this point in time, the Independent Hearings Panel has not made a decision about whether or not they are going to release recommendations throughout that 2-year period, probably from concern that there are so many parts of the plan are interconnected. If you release a recommendation too early, you might want to change it because you've heard another submission on a different part of the plan.
But hang on, Penny, why can't you release the, if as you're determining sites are of no significance, why don't you make them known, and this will save people a hell of a lot of time and money by being able to withdraw from the whole process.
Because the iwi might have a different view.
So in terms of that, it's certainly something we can look at, but we would prefer to finish doing that desktop review of all 3,600, which is likely to be in the first or second quarter of next year, and we can certainly look at how we then use that information before we get to the hearing process.
Just got to look after their jobs.
Okay, sir, you had a question?
In the middle of one of these sites, supposed sites, what I want to know when I do work on it, who controls the charges put out by the iwi? Because I've already had 2 examples of just a bogus charge being whacked on me and me having to pay it. So who's going to control the outcome?
Well, this is the interesting part. The council may have introduced a facilitation service, but you actually have to pay iwi direct. You don't pay the council.
I paid 2 bills on one water discharge. One was $700 and one was $1,600, but it was non-negotiable. Just that's how much we want.
If they have a concern that a site of cultural importance to them, why aren't they genuinely culturally concerned and not asking for any money?
The question is, if iwi are generally culturally concerned about a particular site, why are they providing their advice without asking for money, right? So again, the analogy that Penny used is we commission traffic engineers to advise on traffic impacts of a resource consent. We pay them for the cost of their time for their professional advice. It is no different for iwi providing professional advice.
I have not got property in that position. My property is not one of the ones in the circles. I am here because I care. So if those people care, I'm here at my own cost, I'm going to donate at my own cost. If those people care about something that's important to them, they will do it because they don't need to be paid. It's because it's important. This is all about, an engineer goes for a qualification and is paid for his qualifications, not because he cares about something.
And he doesn't own the bloody road.
So you had a question? Wendy.
I'm in the Hutchison's Coast, just up from the estuary. We've got a new walkway that's gone through. We've got a site that they found some seashells. They put a glass window in front of it. That's just down from my property. I'm just on the edge of the 50 metres. Are all these little piles of shells going to have these little windows everywhere? Is that what's going to happen? I'm just concerned that it's getting out of hand. And did the council actually have to pay the iwi for using the walkway which goes right beside it to make it right?
So I don't know the specifics of this walkway, whether the walkway is on council-owned reserve land. So that would be an instance that the council would have liaised with Mana Whenua on that, and in that discussion, being public land, the way that that particular iwi wanted to recognise the value was through probably the viewing.
But that's only one of the circles. There's several circles along that walkway, but there's also great spaces where there isn't anything. And then there's circles further along the walkway where there is the purple circle. So it doesn't ring true. If they're going to bring their canoes up the estuary and park them and have their picnic with their shells left behind as cultural sensitive heritage things, surely the whole of that area should have been taken in. And to me it seems ridiculous to do 50 metres from that.
So in terms of that particular situation. I don't know the details. In terms of where the circles are, they relate to GPS points which have been identified through that New Zealand Archaeological Association's work. And certainly it doesn't mean everywhere that Māori might have occupied the land or it was a landing point for canoes or something is recognised. And Māori themselves will say that to you, that part of the reason why this is a request for do you want to do a CIA is in many instances in which we describe the numbers, the feedback from mana whenua is no, we don't. It is of no value to us. And so over time as we build up that information, because we also have to remember that the very Māori name for Auckland, which is, you know, Tamaki, the place of many lovers or many visitors, is the fact that there are many instances of different iwi living and crossing through and having battles, having all sorts of things on Auckland. And so that is where, you know, where one iwi might say it's not a value, we need to check with other iwi to make sure it does.
So you have a question here?
I was just wondering, if an iwi was to...
Stand up, we can't hear you.
If an iwi was to proclaim a new site, which at the moment isn't recognised in the Unitary Plan, would the council consider putting that new site on the plan and so someone is subject to its conditions?
So the question was, if a new site was identified by iwi, would the council include that into the Unitary Plan? So as I've just said previously, the council can't amend the Unitary Plan even if it wanted to. But the process going forward from after the plan becomes operative is any new site, we would require that particular iwi to indicate in whatever appropriate manner the value of that site, and then it would have to go through a plan change process which would be publicly notified. There would be submissions to that process and a hearing and the right of appeal, because it would follow the normal plan change process under the RMA. So it wouldn't automatically be put into the plan without any public consultation or hearing process.
In that case, that brings forward the question that was asked before. If a site is seen as being of no significance, why can't it go through that same submission process and be taken off the plan?
Because under the legislation we're working under, we cannot do variations to change the Unitary Plan. Central Government took that power away from Council because we are going through a special process for this Unitary Plan. But through the hearings process, if either the Council has identified or mana whenua, because there are also mana whenua looking at these various sites to give feedback on whether or not they think they should be included, or whether you as a landowner or affected party at the hearings process, the independent hearings panel will hear all of those views, and they could quite easily direct the Council to remove sites off, sites off the schedule of sites of value, as they equally can direct Council to take sites off the schedule of historic heritage buildings or archaeological sites. That is the role of the independent hearings panel once they've heard the various views on a particular issue.
The gentleman at the back has had his hand up for a while. Sorry, on the
These all relate to mana whenua co-governance issues. Every question is
sorry, can't hear.
This all relates to co-governance. What mandate is the Council using to say we need to adopt co-governance with mana whenua? Where did that come from? Could you explain why you're opting this co-governance and giving mana whenua all these opportunities to control these bits of land and things like that, and put submissions in?
So let's get back to this is not about mana whenua having a yes or no opportunity. So under the Resource Management Act, there is an ability for councils to agree with mana whenua to come together and make agreement about co-governance of certain aspects of the RMA. No, we have not adopted any co-governance arrangements. What we have indicated in the Unitary Plan is actually clarifying that the RMA allows that process to happen if mana whenua choose to come and ask Council, are they able to come to an agreement on undertaking certain RMA obligations and processes. For that to happen, the governing body, which is the Council, would have to agree to do that, and they would have to agree to do that through a formal committee process, which would be, no doubt, in the public arena. It has not happened yet, and the only discussions we've had with a couple of iwi is very much confined to the land they already own and where they have aspirations to develop. That's not co-governance, that is us asking for their advice about whether or not these sites are of any value to them. They do not make the decision, we get their advice, the planner or the hearings panel that considers that resource consent application weighs up that advice against all the other advice and makes a decision. It is not mana whenua making a decision on those applications at all.
This goes to the very heart of our democracy, this little discussion here. This is where the public of New Zealand and citizens of New Zealand have not been asked if they want co-governance and co-management. And it's about time people were asked if they want this, and the majority should make the decision. If the majority of Auckland citizens want co-governance and co-management of all their natural and physical resources, that's fine. I'll have to go with that. I'll probably shift to Australia, but I'd have to go with it. But when it's introduced, and the Council has the ability to introduce it through whatever governing body is there, without asking the people first if they want it, then that is not democracy. And I think there should be a referendum on this subject to try and bury this thing once and for all so we get over it, because I don't think it's going to be there. I didn't vote for Colin Craig, but maybe I should have done, because maybe we might have had a referendum on this. It's almost 4 o'clock, but we did say from 1 to 4. Just take a couple of more questions, and then, as I say, we really want to try and form a group going forward from here. And Ben's down the back there. If you can hand in your forms before you leave, so that we can get some sort of group going after this, because it clearly to me that we need to do something going forward.
Thank you. Roger.
So who's speaking?
This is addressed for Roger. Roger, you endeavour to make a comparison with European archaeological sites. And I think this is misleading, because when we're dealing with these sites that are of significance to mana whenua, it does not just mean physical sites, it also means metaphysical. Now that means there doesn't have to be a shell midden there doesn't have to have been a par site. It can be nothing more than the feeling of spirituality that is involved. And that is something it is impossible to assess. The other thing that I should mention here, and I think it's a point that should not be lost, although it has been suggested by Council that only a small number of CIAs have been prepared, I understand that the aspirations of mana whenua is to have CIAs as another level of the consent process. And I understand that their projections are that they will earn anywhere from 25 to 30 million a year from providing CIAs. Now, this is not going to come about immediately, but this is the objective that they see. And that is going to create a whole new regime. Because although it was mentioned before that Maori here were represented, I think you suggested something like 17%, the latest census is Maori are 10% of Auckland's population. And what is being provided for here is a vehicle by which mana whenua will be who represent 10% of the population, will derive an income from the other 90%. And you should all be concerned, and I suggest you give full support to Lee in every way that he can ask for it. And you can.
Yes, sir, we'll take your question.
Thank you. I'd like to ask about conflicts of interest. Earlier, Penny, you implied that if an archaeologist has got a view and mana whenua have got a view, the mana whenua will prevail over the archaeologist because, as you said, the mana whenua actually want to provide that advice themselves. Roger, you drew the comparison with a traffic engineer. The people here this afternoon, I think, are intelligent people. Can you not see the potential for a conflict of interest where you have a traffic engineer engaged to provide advice on a specific engineering issue? Can be no conflict of interest in the normal sense of the word, but if you go to the mana whenua to ask them for that same advice, they've got a vested interest in providing it. That is sacred. This gentleman here has talked about an income of $20 to $30 million a year. I don't know if that's true or not, but it seems to me that there is a conflict of interest. And as the leader of the planning department at Auckland Council, you must surely see that conflict of interest. And so my question is, do you see that conflict of interest? If you do, how do you intend to deal with it? And if you don't see the potential for conflict of interest, how can the people in this room have any confidence in your ability to do the job?
Well, so first of all, to address your point about what the previous gentleman said, to suggest this is a huge revenue generating opportunity for iwi is nonsense. It simply is not. And Stephen made the point at the start of the meeting when he spoke that the revenue generated out of this is trivial compared to the treaty settlement process issues. To go back to the question at the back here, the question at the back was, is there a conflict of interest for iwi in giving their advice on cultural heritage values associated with particular sites? And I think the key point here is that the iwi do not make the decision. Shane Jones was wrong when he said that there are 19 iwi consent authorities being set up in Auckland. That's wrong. I've rung him up and I've told him he's wrong. The iwi do not make the decision, it's council that makes the decision. The iwi give their advice in the same way as a traffic engineer gives their advice. Council makes the decision, so there's not a conflict of interest.
With respect, let me ask a question into Penny, because I drew the specific inference from you earlier this afternoon, about half an hour ago, that if you had an archaeologist drawing a particular conclusion, and the mana whenua drew a different conclusion, the mana whenua conclusion would prevail over the expert archaeologist.
Yes.
Did you say that or imply that, yes or no?
I think you have perhaps either I'm not very good at communicating or you've misheard what I said, but that comment was made where somebody had said the archaeological society had indicated that they did not believe that site was of value. And my view was that they might have said that in terms of their expertise as archaeological people, that it wasn't of value as an archaeological site in the general sense. But the question that we are asking mana whenua, is it of value to them as mana whenua, not as archaeological people? And that's the difference. And so you would take, if you were a resource consent planner who got the advice of the Archaeological Association, you got the advice of mana whenua, and you probably would have got some advice from a planner or something else. That is your role, to look at each of those advice, balance it up, weigh it against the rules in the plan and the objectives and policy, and make a recommendation and a decision. It is not any one of those inputs' role to make a decision. So I don't believe I was saying you'd choose one over the other. I just said they had different expertise that they would be putting in as input into the resource consent process.
Remember the Waikato Expressway.
Thank you very much, Penny and Roger, for coming along today. So we're just going to wind the meeting up very shortly, but I think it would be good to finish this meeting with some resolutions that perhaps I could put to the meeting. These are the meeting resolutions that the government passed legislation to end the Mana Whenua provisions and restore proper application of existing law, in particular the Heritage New Zealand Haurutanga Act 2014. So we're asking the government to step up here and sort this out. The second one is that council suspend application of the Mana Whenua provisions. I'm not sure if they can do that, but I'm sure if they had a will they could probably do that. And the council undertake to vary the plan by removing the requirement for CIAs, the 3,600 sites, and place the value to Mana Whenua and other provisions not properly approved by councillors. So I'd like to put those three resolutions to the meeting, and can I get a sign of affirmation from people who would agree with those resolutions? Yep. Thank you very much. I do thank you very much for coming along today. Please give us some support going forward. A special thanks to Sir Bob Jones, who looks like he got out of the sick bed to come today. He was very good for him to come. And as I say, I wish we had more leaders with some guts and determination that he's got and would speak up on this issue. Thanks very much to Stephen and Pam, who have done a lot of work here. And thanks very much to all the people who have helped out today. I'm very grateful that so many people have attended today and contributed, and the meeting would not have been a success without your help. Yes, ma'am. Yes, well, that's a very good idea to put a letter on the website you can download and send off to John Key to get this thing sorted out. So we will do that. Thank you very much. And thank you so much for attending today.
If I could just have everyone's attention, I'd just like, as a guest here, to thank Lee Short. I think that this is a deserve that must go on. Lee has put a tremendous amount of time, effort and money into all this, and we really do need support financially. If this is going to go forward, it does need financial help. And I really feel that if the democratic result to all this is going to be achieved, then we really need to put our hands in our pockets to help. And he's got a little card I see we can fill in and donate some money to his cause. I'm going to put my money where my mouth is, and I'm donating $5,000 on mine. So that's a start. So let's all put our hands in our pockets, and thanks to Lee to continue this onwards and upwards.